Welcome back to the Ask Rusty Law podcast. I'm your host, Rusty Messer. Today, we are talking about the discovery process. Why is the discovery process slowing down your lawsuit? So you called your lawyer for an update. She said, hey, we're still in discovery. What does that even mean? We will break down what the discovery process is, why it's taking so long, and why it has to happen. I want to talk about something that frustrates a lot of my clients. And honestly, I totally understand why. So you've been hurt in an accident, you've hired a lawyer, and then nothing seems to happen for months. So you're wondering, what's taking so long? Why isn't my case moving faster? Well, one of the biggest reasons cases take time is something called the discovery process. And that's what we're diving in today. So first of all, let's talk about what is discovery. Think of the discovery process like this. Imagine you're putting together a giant jigsaw puzzle, but half the pieces are scattered around different rooms in different houses. Discovery is the process where both sides, your attorney and the other side's attorney, go hunting for all of those puzzle pieces. So we're gathering evidence, we're interviewing witnesses, we're collecting documents to build the strongest possible case. Now, I know what you're thinking. Rusty, can't we just skip all this and get to the courthouse? Trust me, I wish it were that simple. But here's the thing. Discovery isn't just some legal formality we lawyers dreamed up to make more work for ourselves. It actually protects you. It ensures that when we do get to court, we have all of the facts, we have all of the evidence, and we give you the best possible chance of getting the compensation that you deserve. There are three types of discovery, and I want to walk you through each one so you understand what's happening behind the scenes in your case. So the first type is written discovery, and this is exactly what it sounds like. Questions and requests that get sent back and forth on paper, or more likely these days by email. So there are three main types of written discovery to talk about. One is called interrogatories, and interrogatory is basically a fancy word for written question. Think of it like a really detailed questionnaire. We might ask the other driver, exactly what were you doing in the 5 minutes before the accident? Or have you been in a car accident before? So they have to answer these questions under oath, which means lying can get them in serious legal trouble. This is important because we can learn things that impact your case. So let's say the other driver says, well, he was leaving his cousin's house just before the crash. And later we talk to the cousin and we find out they were drinking beer and watching a ball game. That can affect your claims in a car accident case. The second type of written discovery is what's called a request for production. And this is where we ask for documents and physical evidence. We might request their phone records, maintenance records for their vehicle, or any photos they took at the scene. If it's a slip and fall case at a business, we'd ask for surveillance video or maybe incident reports, perhaps maintenance logs on a leaky refrigerator, something like that. So we're getting physical documents or physical evidence that might help your case. And the third type of written discovery is what is called a request for admission. And requests for admissions are where we ask the other side to admit or deny specific facts. For example, admit or deny that you were traveling over the speed limit at the time of the collision. This helps narrow down what we actually need to fight about at trial. Now, here's something important to know. When someone gets served with written discovery, they typically have 30 days to respond. And that might seem like a long time. But remember, they need to gather documents, review records, often consult with their own experts or their own witnesses. So it's not uncommon for the other side to ask for more time to respond to the discovery request. And most lawyers will agree to that request because they know one day they might be the ones needing some extra time. Sometimes your client just may not be able to get together documents and records in 30 days. So maybe you're waiting on tax returns from your CPA. Maybe you're trying to find old credit card receipts. But sometimes the other side just does not answer. So what happens if they don't answer? Or they give us some wishy-washy non-answer, which is very common. That's where something called a motion to compel comes in. Basically, we go to the judge and say, Your Honor, we ask a reasonable question and they're not playing fair. The judge can then order them to provide proper answers and sometimes even sanction them for not cooperating. There is a legal process for filing a motion to compel, and it can take 2 to 3 months to go through the process. You file the motion to compel, you have to get a judge to set it for a hearing, you actually go have the hearing, you got to get your judgment signed. So that alone can slow down the case in the discovery process. So the second type of discovery that I want to talk about are what are called depositions. And a deposition is where things really get interesting. So a deposition is where we put someone under oath, just like in a courtroom, but we normally do it in a conference room with a court reporter typing down every word. Sometimes we video them so we can show the video at trial. We might depose the person who hit you, any witnesses to the accident. We might depose your doctors. If we have expert witnesses like a crash reconstructionist or a life care planner or something like that. Really, anyone who has information that could help or hurt your case. The other side is probably going to depose you. They're going to want to depose your witnesses. And this process can take several months depending on how many witnesses need to be deposed and how many lawyers are involved. So we usually won't even start with depositions until at least some of the written discovery has been done. Then you have to pick a date that the witness and all of the lawyers are available. So I always tell my clients that depositions are nothing to be scared of, but they are important. So the other side's attorney is going to ask you questions about the accident, your injuries, how those injuries have affected your life, and all this is under oath, right? So you're sworn to tell the truth. Your job is simply to tell the truth. My job is to prepare you beforehand and make sure you're ready. Make sure that you recall the facts of your accident that might be in writing, but maybe you've forgotten about because the accident happened, a year or two ago. So for the other side, depositions are our chance to lock them in to their story. So if someone says one thing in a deposition and then tries to change their story at trial, we can use their deposition testimony to call them out on it. And the third type of discovery that I want to talk about is what is called a subpoena. So a subpoena is basically a legal demand that we can have the court issue to witnesses or even third parties. We can subpoena people or companies who aren't directly involved in the lawsuit but have information we need. For example, if we think the other driver was texting when they hit you, we can subpoena their cell phone company for their call and text records from that day. If you've lost wages because of your injuries, we might subpoena your employer for payroll records to prove exactly how much income you've lost. We can also subpoena witnesses to appear for depositions or to come testify in court. And the great thing about subpoenas is that they carry the power of the court. If someone ignores a subpoena, they can face serious consequences. Like everything else, there are time delays and a legal process for issuing subpoenas. Why does discovery take so long? And this is the million-dollar question. Why does this all take so dang long? So we've discussed this a little bit, but let's look deeper into it. So think about it this way. In a simple fender bender with minor injuries, we might only need to depose a few people and gather some basic documents. That could take a few months. But in a complex case, say a truck accident with serious injuries, we might need to depose the truck driver, their supervisor, the company that loaded the truck, a mechanic who worked on the truck, several of your doctors. Maybe we have an accident reconstructionist expert, maybe an economist to calculate your future lost wages. So you get the idea. It can be a lot of depositions to take. Each deposition has to be scheduled around everyone's availability. Documents have to be requested, reviewed, and organized. Doctors usually only do depositions on certain days and at certain times. And experts might be from out of town, so they have to make travel arrangements. So in really complex cases with lots of witnesses, discovery can take more than a year. And I know that's frustrating when you're dealing with medical bills and lost wages. But remember, every piece of evidence we gather is ammunition for getting you the best possible result. Not doing a full discovery process can result in not being prepared for trial. And you usually only get one shot to present all of your evidence and to present your case at trial. I get it. When you're hurt and you're struggling financially, waiting months for your case to progress feels impossible. Here's what I want you to remember. Discovery isn't delay for delay's sake. It's the lawyer doing the hard work of building your case brick by brick. So every interrogatory answer that contradicts what a witness said before, every document that shows they knew their equipment was dangerous, every witness who saw what really happened, all of that comes from the discovery process. And all of that helps us fight for every dollar you deserve. So that wraps up today's episode of the Ask Rusty Law podcast. If you found this helpful, make sure to like and subscribe and share it with anyone you think might benefit from it. So understanding how the legal process works can help you understand more about your case and the types of claims that you have. Until next time, I'm Rusty Messer reminding you to stay safe out there, and if you need us, we'll be ready to fight for you.